Hello, my name is Malcolm Skinner and I'm a solicitor in the LexisNexis PSL private client team. Today I'm joined by Matthew Braithwaite, who is a partner at Bircham, Dyson, LLP, and we're going to talk about foundations. Welcome, Matthew.
Thank you.
What are foundations?
Well, foundations in the context we're talking about here are what we describe as private foundations. They're not charity foundations as we typically understand the term.
Sure.
And just to cause confusion, a lot of charitable foundations are in fact trusts.
Right.
But the purpose of what I'm to explain is that there are key differences between foundations and trusts, and indeed foundations are alternative forms of asset holding structures which are commonly used in wealth structuring for clients. The main sort of characteristic of a foundation is that it's a civil law concept, not one of common law like a trust. And Liechtenstein is one of the first offshore jurisdictions which developed the concept of the private law foundation. For English law purposes, foundations have never really formed part of English law, which is often where difficulties arise. And as I mentioned, they often are viewed as alternatives to trusts. In recent years, we've seen a number of common law jurisdictions, though, developing their own foundation laws, which is primarily a recognition of how much more popular foundations have become as wealth holding structures, and in fact structures used in conjunction with trusts. And most recently in Jersey and Guernsey, they've in fact adopted their own foundation laws, which have seen some uptake. And generally, the use of them in those jurisdictions is, as I said, to facilitate the structuring, but also to provide a shop window for the services they can offer, not just for individuals in common law jurisdictions, but also those more further afield who are perhaps more comfortable with the use of foundations.
So, obviously foundations and trusts are different for different purposes, and they have some similarities as well. What sort of similarities and differences do they have?
Well, they are quite distinct in a number of respects. Foundations themselves, in fact, have separate legal personality, whereas we know that trusts don't.
Yes.
And it's the trustees who are personally liable for the acts of acting as trustee. But in terms of a similarity is that the founder transfers assets to a foundation in the same way a settlor would do to a trust. The terms of a foundation are set out in a deed or a charter, and it also has supplementary articles, bylaws or regulations depending on the jurisdiction you're dealing with. The charter typically sets out the basic facts of the foundation, the name, the objects, information relating to its winding up in due course, and also details of the initial endowment, i.e. the funds that it holds. And the bylaws or regulations set out how the objects should be carried out, and includes details of the foundation council, how they are appointed and or removed or retire, and also how decisions are to be made. So it contains the nuts and bolts of how the foundation operates. Trusts, as we know, are governed by a trust deed, and there's some degree of guidance if a letter of wishes is provided at the same time. Foundations are administered by a foundation board, and really how that's governed is depending on the express terms of the foundation charter and the associated documents, whereas as we know with trusts, we look primarily at the trust deed, but also there's this overarching fiduciary duty, and also there's recognised legislation that imposes certain duties on trustees. Rights can be reserved to founders in the same way that rights may be reserved to trustees, but the ability to reserve rights to a settlor, the ability to reserve rights to a settlor in a trust is often slightly contentious, particularly if the trust happens to have some sort of UK connection. We would argue that the trust wasn't in fact a sham, whereas there's a greater degree of separation between the founder and the foundation itself.
Sure.
For a foundation, there's no requirements to have beneficiaries. They could be contained in the supplementary bylaws or regulations, but there's they're not intrinsically part of a foundation, whereas as we know for a trust it's important to have at least a certainty of objects, i.e. beneficiaries, to make the trust valid. Foundations can exist indefinitely, which is something that's quite distinct particularly from English law trusts.
Yes.
But as we know in trusts in other offshore jurisdictions, like for example Cayman and BVI, and even in fact I think more sort of local offshore jurisdictions, trust periods can be unlimited now. So again, it depends on the jurisdiction, but of course for an English law trust we have to have a perpetuity period.
Yes,
so there's a key difference there.
Yeah.
That's the general sort of roundup really of the key differences and also the similarities.
Okay, so why then would somebody choose a foundation rather than a trust? What might be the criteria for that?
I think it depends really on what the use of the foundation is. If it's the primary asset holding structure, I think that comes down more to the mindset of the client and what they're comfortable with. If they're from a civil law jurisdiction, they're less akin to the concepts of equity that enshrine the use of a trust. So they like to see the black and white nature of a foundation. Conversely, with a foundation, there's the express ability to retain some degree of control, which clients often do like as well, which is probably why we've seen the emergence of trust that slightly watered down the concept of trust to give settlors the ability to have control in order to perhaps align themselves more to foundations. But also it depends on what the foundation is being used for. Typically, in the context of some trust planning, again with an eye on control, certain clients want to set up private trust companies. Now that's an example where a trust and a foundation might actually interrelate quite nicely, and the foundation would take a subsidiary role because it would perhaps be the holder of the shares in the private trust company to provide a degree of separation between the settlor and the trust company. So a foundation could be useful there, and in that case the trust is the primary structuring vehicle, and the foundation could be used as more of a discrete part of the planning, and the client may be less concerned about the use of a foundation in that context. And it might explain why in certain jurisdictions like Jersey and Guernsey, why we've seen the emergence of foundations, because they are useful in terms of being able to be used as owners of private trust company shares, for example.
Well, you've convinced me I want a foundation, so how do I go about setting one up?
Well, there are of course more formalities for setting up a foundation than we would typically see for setting up a trust.
Inevitably, yes.
Because we are effectively establishing a separate legal entity, which in most jurisdictions, whether the foundation is set up, it would need to be registered accordingly. But as I mentioned, it really very much depends on the jurisdiction involved, because although we describe foundations generally, their attributes vary from jurisdiction to jurisdiction.
Oh, right, okay.
And of course we appreciate that a trust can be set up relatively informally if we simply establish that we have the three certainties and the trust is constituted in the right way. And for some more modern foundation jurisdictions like Jersey, there is a requirement that you have a regulated member of the Foundation Council. So it would be perhaps one of the trust companies who would have to act as a regulated member, and therefore you'd have to get the relevant approval, and again an extra layer of formality. So if you are going to set one up, you'd have to have regard to those formalities.
A little more complex.
Yes.
The inevitable question, as clients always ask us, what are the tax consequences of setting up a foundation?
Well, this is the nub of it really. This is the
always is
the aspect of wanting to establish a foundation and trying to marry that into concepts of English law, because as we've already identified, English law doesn't recognise the concept of a foundation. So how do you categorise a foundation under the general concepts we know? The starting point is the general law, in the lack of any precise English equivalent to such a structure, and that looks to whether the entity itself is transparent, i.e. like a a trust, i.e. it's look through, or it's opaque like a company. And the leading case on this is MEMIC and the IRC, which is a Court of Appeal decision, and the principles that were discussed in this were adopted and have been adopted by HMRC, and the principles were broadly set out in their international tax manual. So we generally had an idea, and in fact they'd gone to the trouble of setting out some examples of entities that they were aware of and how they would typically regard them to provide us with at least a head start on where to begin. Now, more recently, in the case of Anson versus Revenue and Customs Commissioners, the Supreme Court disagreed with HMRC's interpretation of the income tax treatment of a US LLC, a limited liability company.
Good old Supreme Court.
So HMRC are rather licking their wounds as a result of this, and unsurprisingly, you cannot currently find the International Tax Manual relevant pages to establish these general law principles on certain entities, which is less than helpful.
Indeed.
So what we can do is look at some more general principles. And HMRC have commented previously in the context of the Liechtenstein Disclosure Facility, I must add in connection with Liechtenstein foundations, that they've noted that the essence and purpose of a foundation is to preserve and maintain the assets for the beneficiaries, and is therefore akin to that of a trust, which is helpful.
Yes.
But we can't just accept that for every foundation, given that the laws of each foundation differ. So more generally, if you're looking at trying to establish that a foundation is more akin to a trust than a company, you'd want to ensure that it comes within the definition of a settlement for the purposes of Section 43(2) of the Inheritance Tax Act 1984, which helpfully is widely drawn and includes entities that are equivalent in effect to trusts.
Right.
But again, it's a case-by-case basis, so it's less than ideal. For capital gains tax purposes, we would perhaps consider more the offshore capital gains tax provisions and the test contained in Section 620 of the Income Tax, Trading and Other Income Act 2005, which again is widely drawn, but each case has to be considered on its facts. So there's no general principles that we can draw in terms of how a foundation would be taxed.
It's a bit like shooting in the dark, really.
Well, it is to an extent, and it's not helped by the fact that most of the trust provisions, or the provisions we would see as akin to trust, would be contained in the document that isn't the registered document.
Indeed.
It's the one that could perhaps be modified.
Yes.
So it's a bit of a moving target.
Okay. Well, obviously, gains and income are generated by the foundation. That's the purpose of it, ultimately, presumably. But how do the UK tax, so what is the UK tax situation when we do have income and gains?
Well, broadly, they follow the treatment of a company, because we are dealing with a separate legal entity. So it comes down to where is it managed and controlled. And if that management and control takes place in the UK, then it's regarded as resident in the UK for tax purposes.
So we're moving into a trust scenario there, aren't we, where the same principles would apply?
Well, quite, yes. So in a sense, we're dealing with the management and control are points that we would consider for company residence purposes. But we are sort of straying in, it's this sort of general overlap in terms of principles, and whether a foundation is regarded as one entity for one purpose and another for something quite distinct. But the obvious point to mention there is, of course, if the management and control are outside the UK, then the tax position is somewhat different, because we haven't got immediate exposure to UK tax, apart from, of course, if the foundation owns a residential property from April
2017.
April 2005 in terms of capital gains tax,
yeah.
because it would be treated as a non-resident owning UK residential property. So again, each scenario depends on its facts and what it's actually doing.
Okay. So we have income and gains there. What about IHT?
For inheritance tax purposes, we are back to the principle, is it a settlement for inheritance tax purposes? And without wishing to sound repetitive, it depends on the nature of the foundation. But if we are looking at a foundation that's more akin to a trust, query then is it holding UK cited assets? Yeah. And if so, it's subject to the relevant property regime in respect of those assets. Or if it's a company, is it a close company? Is it controlled by 5 or fewer participants? And there are some nasty inheritance tax rules to consider there, which is probably taking us down a road that we perhaps don't want to be going. But
Absolutely.
Certainly we would want to make sure that the foundation is more akin to a trust in that situation rather than a company.
Okay. So we've dealt with the tax position of the foundation. Obviously the beneficiaries are sitting there, they're getting income from the foundation, they're getting something from the foundation. How are they going to be treated from the point of view of UK taxation?
Well, I think broadly we're looking at general anti-avoidance provisions that exist in the UK for the receipt of any income and gains from a foreign located entity, and for income tax purposes, if the foundation has relevant income within it and the beneficiary receives a distribution, then there's the matching of that income to the distribution, and therefore the UK resident beneficiary would be subject to income tax on the receipt of that income. And that's broadly regardless of whether the entity was treated as a trust or a company. For capital gains tax purposes, it depends really on the treatment of the foundation, whether it's more akin to a trust or a company. If it's akin to a trust and there are gains realised in the same tax year that distributions are made, you've got the matching of those gains in the same year. Or if the distribution's made in a year where there hasn't been any gains realised, but there are stockpile gains within the foundation, then you've got the matching rules there. So the gains would be matched to the distribution to the extent that it's not matched to the relevant income. If it's a company, you've got the attribution rules under Section 13 under the Taxation of Chargeable Gains Act 1992. So the gains made by the company would then be treated as taxed on the participants, as it were, if it was regarded as a closed company. So you've also got the motive defence, which may circumvent the effect of those anti-avoidance provisions. So again, it very much depends on the facts.
On the facts, indeed. Okay, well, the one thing that is occupying all our minds at the moment is CRS. How do foundations fit into that particular situation? Where are we with foundations and CRS?
Well, I suppose the short answer, which is consistent with the overall message, there's no clear answer. And like trusts, they each have to be considered on a case-by-case basis. I mean, it broadly fits into whether the foundation amounts to financial institution or whether it's regarded as a non-financial entity. And in order to determine that, we need to know what the foundation is doing. Does at least 50% of its gross income come from reinvesting or trading in financial assets? Or, as I mentioned earlier, if there's a financial institution that's on the board, maybe it's a registered trust company in the jurisdiction, and where that's managed by if the financial institution is managing the foundation, the foundation itself could in fact be treated as a financial institution itself. So it does, as I say, depend on the nature of the assets and the management of the foundation to determine that status. And if, of course, there's a requirement on the Foundation Council to carry out due diligence in respect of its beneficiaries, if we can in fact establish there are any beneficiaries. And by that we probably mean, has anybody had the benefit of distribution of the foundation, if that's at all possible to establish. And also due diligence on who's got ultimate effective control over the foundation. Now that may also be difficult to determine. But if I take the example of a more modern foundation where you've got the ability to appoint a guardian, for example, which could well be the ultimate owner who wants some degree of control and wants to oversee the actions of the council, it may be that they have got that ultimate control and could be required to be disclosed to the relevant tax authority. But again, it comes down to the facts of the case and what the actual role of the guardian is doing. So again, it's a question of fact, and it's not ideal, but like trusts, it's kind of marrying some of these more less helpful definitions to what's going on to the actual particular scenario to arrive at a conclusion.
If a conclusion can be reached.
If indeed possible.
Matthew, that was absolutely fascinating. Thank you very much for coming in.
That's okay.
Very kind.
Thank you.
Thank you.